Republic of Germany suggests, such restrictions are in fact valid, Your Excellencies.
You've had a lot of questions and
Yes.
your time is up, but I'll give you another 30 seconds just to sum up what you want
Much
to
obliged, Your Excellency. Just to sum up my last contention on reasonableness, it is submitted that for a restriction to be reasonable in the United States, there must be a clear and present danger, as elucidated by Justice Oliver Wendell Holmes in Schenck versus United States. Under the European Convention, there must be a pressing social need. Now, in both these instances, because of the factual circumstances that I've pointed out, the provocative insults, the provocative posts, etc., because they incite racial hatred and because they incite a threat to national security, constitute political hate speech, which in this case can be reasonably restricted, taking into account that the state does have a broad margin of appreciation, Your Excellencies.
Thank you.
If Your Excellencies have no further queries, I'd like to call on my co-agent to deal with his submissions. It has in fact been a pleasure to argue in front of us.
A very good afternoon, Your Excellencies. This is Agent number 2 appearing on behalf of the state in the matter relating to Open Bamidia versus the Republic of Bamidia. The agent has primarily 2 contentions to make, both of which pertain to the right to privacy. The first of those contentions is that the right to privacy of the applicant's users in the instant matter has not been violated. Under this contention, the respondent primarily will submit in 3 limbs. Firstly, that there exists a situation of public emergency and a state be allowed to derogate from its obligations. In the alternative, the agent will submit that there is no reasonable expectation of privacy of the users in the instant matter. In the alternative, should the court hold that there is a reasonable expectation of privacy on the part of the users, the agent will submit that the restrictions in the instant matter are necessary and proportionate. If that explains the scheme of the presentation today, the agent will move on to the first submission with regard to the public emergency. Your Excellencies, if I may now draw your attention to footnotes 86, 87, and 89 of our written submissions on numerical page 12. Your Excellencies, in the absence of the definition of public emergency in the Covenant on Civil and Political Rights, as well as the ECHR statute, we shall primarily rely on judicial decisions given in this regard. Your Excellencies, in the decision of Brannigan and McBride versus United Kingdom, as well as Lawless versus Ireland, the court held that for proving a public emergency, it must be established that an exceptional crisis has gripped the entire population. In the same cases, it was held that the court must be satisfied that all other existing measures taken by the state have failed. Existence of a secret militia inciting or committing crimes proves prima facie before the court that there exists a public emergency. Your Excellencies, in the instant matter, all the requirements are satisfied. There is the existence of a secret militia called the MLM. There's also a very strong suspicion that the activities on the internet and the activities of the secret militia are connected. We have taken all sorts of measures, including amending the military secrets law, and added the IRA only as a measure of last resort. Therefore, I urge this court to believe that the state be allowed to derogate from its obligations and take certain decisions and make laws which are needed in the interest of the country by affording it a wide margin of appreciation. However, should this court believe that the state should not be allowed to derogate, then it is my submission here that the users have waived their reasonable expectation of privacy. Your Excellencies, if I may draw your attention to the case of Malone versus United Kingdom, as well as the US decision in Katz versus United States, a prerequisite for establishing the right to privacy is that a person must have a subjective satisfaction of privacy. Your Excellencies, if I may now draw your attention to the famous US decision of United States versus Miller. In that case, the court held that where a person voluntarily discloses certain information to a third party, the reasonable expectation of privacy goes down. In the instant matter, therefore, people have voluntarily subscribed to the website by giving certain information about them, which includes their geolocation tracking, because this is a tracker forum. Hence, Your Excellencies, their subjective expectation of privacy does not exist, and they have waived their subjective expectation of privacy. Should that, if Your Excellency...
Counsel, I'm sorry to interrupt in a way, because my question is about the basis for referring us to the United States law. Why would it help us in applying the Universal Declaration to know how the American judges have interpreted what their founding fathers did in constructing a constitution for that country? Can you help us? Why would American law even be helpful in deciding what the extent of the right is under the Universal Declaration?
Your Excellencies, I do understand that there is a difference in standard in the way American judges have interpreted the Fourth Amendment, and there's a difference in the way right to privacy has been viewed by the European Court. In a sense, in the American jurisprudence, there is the test of the subjective as well as the objective test of reasonable expectation and whether the society considers it reasonable. And in the European Court, there's a test of necessity and proportionality. However, Your Excellencies, I would draw your attention to the fact that both of the jurisprudence in Europe and America stress on the fact that it has to be established that there is an actual subjective expectation of privacy. And I was only citing the decision in US versus Miller to state that where a third party has been given certain information voluntarily by a user, that subjective expectation of privacy is lost. However, Your Excellencies, if this court is not persuaded by the fact that this decision should bind this court, then I submit that within the domain of the Universal Declaration of Human Rights...
But even if, sorry to interrupt again, but even if we are convinced with the decision in Miller, I still don't see the applicability, because in Miller there's a risk factor that was produced, and which you need to explain to us how reasonably that user of it is expecting that. And there's the subjective expectation of privacy, and there's the issue of voluntarity. You are not really given them much chance here in this particular situation. Why not just do that to all internet users in the country?
Your Excellencies, first of all, Open Media is a tracker forum where the geolocation is tagged. So
and there's a popular website at the same time.
Definitely, Your Excellencies. And therefore, when someone makes a post on Open Media, the person voluntarily subjects himself or herself to be geolocationally tagged. With regard to the fact...
But not knowing where that information is going, do they?
No, Your Excellencies.
Because they are assuming that it is a two-way line, if I'm not mistaken.
Your Excellencies, they might not know where that information is going, but to the extent that they have supplied that information or that information is made public to the third party, which is a website in the instant matter, they have waived their subjective expectation of the right to privacy. It's no longer private. It's a matter that's already there in the private domain, which is why they have waived it to the extent that they voluntarily chose to post on the website. However, Your Excellencies, if the court is not satisfied that they should be persuaded by this decision of the United States Supreme Court, I will establish that under the Universal Declaration of Human Rights, as well as under the ECHR statute, the measures are necessary and proportionate. Now, Your Excellencies, in a series of decisions, which includes Truslin versus France, as well as the much-quoted decision of Klaas versus Federal Republic of Germany, the court has held that a threefold requirement must be satisfied to establish that restriction is reasonable. First, the restriction must have legitimate aims. Secondly, the restriction must be necessary in the context of a democratic society. There must be a compelling need. And thirdly, the restriction must ensure that it is lawful and as per law. Your Excellencies, before I move on to establishing that all the requirements are satisfied, let me briefly elucidate before the court as to what is the purpose of the Internet Responsibility Act.
Counsel, I'm sorry to interrupt you. When you refer to reasonable expectation of privacy, are you in fact telling us that any user that wishes to limit the information provided by him is equally trusting open the media and the government and the remaining users in a limited circle of exchange of information? Are you telling us that any such user is to be expected to have a reasonable, is to be seen as having an equal reasonable expectation to privacy in comparison to all these parties?
Your Excellency, my only statement is this, that once a user knows that this is a tracker forum which tags a geolocation, and the user chooses to post on such a tracker forum by voluntarily disclosing information about identity, website, other requirements that the website has, then to the extent that the information has been disclosed voluntarily, the subjective expectation of privacy on the part of the user is lost. That's my submission, Your Excellency.
Under the same logic, could you require all cell phone users in the country to collect information about the location of the users and also to monitor their phone calls under the logic that if somebody chooses to buy a cell phone and to use a cell phone, that they're subjecting themselves to that and voluntarily waiving their rights?
Your Excellency, if I may point out two differences in between the example that's been cited by Your Excellency. First of all, with regard to mobile phones, anyways around legislations across the world, the particular location of the mobile tower in which the call was made can anyways be revealed to the government. With regard to the content of the telephone conversation, that cannot be interfered with by the government, and in the instance statute itself, we have left out the content of the information. If the statute were to regulate content as well, we would not be standing here before this court and justifying that it is reasonable and proportionate. If Your Excellencies permit me...
But you are asking for content and of some other forums as well here, yeah?
Your Excellency, we have not sought the content of any information. Your Excellency, the scheme of the Internet Responsibility Act is only this, that it only permits the government to identify certain users. The Internet Responsibility Act is not a penal statute for users. There's no penalty for the users under the Internet Responsibility Act. What we are trying to do very simply is this. We have a specific watch list of people we suspect of indulging in terrorist activities. We have exhausted all our resources in finding out who they are. Now there's a website which geolocates certain people. Now, if it so happens that there's a suspicious posting on the website, and from the website we know the identity of a person, the address, and where the post was posted from, and compare it with our watch list, we can go and nab that person. And if it so happens that the person has indulged in commission of a crime, then we can prosecute them under the ordinary laws of land, and they will be entitled to all sorts of protection that the penal statute has. The entire purpose of this statute is only restricted to identifying people and not punishing people.
But counsel, the Act goes further than that, doesn't it? Because it allows you to request the details of any user without giving any justification.
Your Excellency...
You've explained how you might use it, but that's not how the legislation is framed. Is that right?
Your Excellency, the request will be made on a case-to-case basis. And if paragraphs 15 and 16 are any pointers to the way this has been used, so far this has only been used with regard to the people on whom the government has a strong suspicion. Also, I would point out, Your Excellencies, that I do understand that this court might be feeling that there is an incessant need for some sort of a judicial review. And I will draw your attention to the very curious provision of Section 2703 of the Stored Communications Act in the United States. Now, the provision, very curiously, speaks about a judicial inquiry, speaks about obtaining a warrant by means of federal rules of criminal procedure on the one hand, and the second paragraph of that section says there is no need to obtain warrant according to the federal rules of criminal procedure. Well, the natural question that arises is, what is the line of distinction? Well, the line of distinction is only this, that under the former, the government can access the content of electronic or wired communication, while under the latter, in which there is no need of judicial review, the government can only seek non-content information, which is only identifying certain people. And that's what we precisely want to do here. By means of a statute, we want to identify certain people. If they have violated the military secrets law, we'll prosecute them under that law. If they've violated a terrorist legislation, we'll prosecute them under that law. And that too on a case-to-case basis. There's no presumption of bad faith on the part of the government to state that we will target people and hunt them down by means of the Internet Responsibility Act. This does not contain a single penal provision with regard to any of the users. This only serves the purpose of identifying people, comparing them to our watch list, and seeing if they can be prosecuted under the ordinary penal laws of this country. Your Excellencies, I will now move on to stating that this law is supporting a legitimate aim and there is a compelling need. Your Excellencies, as a matter of fact, national security is a legitimate aim according to Article 29.2 of the Universal Declaration of Human Rights, as well as 19.3b of the International Covenant on Civil and Political Rights. Your Excellency, all that we need to establish, therefore, is a direct connection between the restriction and what we seek to achieve by it. Your Excellency, my co-agent has already drawn your attention to the fact that there are private forums about which we have no information. Therefore, the direct link in between what we purport to achieve is to find out some information about these forums. And once we do, it will only help us in improving not just our national security concern, but we will ensure that only those who are guilty are punished, and therefore the ethnic tension in between the communities will also come down. These are the three legitimate aims that the Internet Responsibility Act supports. Your Excellencies, I will also submit that there is a compelling need, and the measures are least restrictive. The reason why I say it's a compelling need is because we have exhausted all our measures, including amending the military secrets law. And this law was promulgated only after all sorts of measures were taken. Now just imagine if there were a contention that the military secrets law is in fact enough to take care of the situation. I will illustrate how it's not. Your Excellencies, now we have a law which prevents the dissemination of information about the location of the military, which is the military secrets law. But what if someone violates the military secrets law and still reveals the location of the military? How do we know where the person is?
Why is it a secret? It's just any information about the location of military personnel.
Your Excellencies, because if I may draw your attention to paragraph 12 of the fact sheet, in light of the severe ethnic tension and emergency that exists, in two separate instances, government attempts to prevent bombing attacks have failed, even though the government was acting on solid information about the likely target. Marketplaces have been bombed. A parliamentarian has been killed. There is a severe ethnic tension, which includes the existence of two secret militia, and government efforts are being foiled time and time again because the real-time location of the military is being disclosed. Therefore, we brought the military secrets law, the amendment to the law, and now we need to aid that statute by means of the Internet Responsibility Act so that we can identify those people who are violating the provisions of any of the penal laws of this country. If your Excellencies are satisfied, I have a submission to make with regard to the First Family Privacy Act.
Yes.
Your Excellencies, my learned friends on behalf of Open Media have very rightly conceded, and we accept 2 points with regard to this submission. One, that there has been some infringement on the right to privacy of the First Lady and her 2 minor children. And secondly, they have also conceded that if it were to be a law concerning the 2 minor children, both of whom are aged 8 and 10, then they would probably not have any problem with this legislation. Your Excellencies, therefore, that only leaves us with the question of proportionality and whether the restriction is valid. If there is no debate on the fact that the cause that's making the state deliberate upon the legislation is a cause that is valid, which means